Hello viewers, this is Just Connect Online TV, your show, The Legal Corner. I'm joined with our legal expert, Mr. Kyalo Wambua. Karibu sana.
Asante.
He's an advocate of the High Court, and he'll tell us more about what he does, though we have interacted with him in the past. And today we are going to talk about succession. Karibu sana.
Asante sana. My name is, as you have heard, my name is Wambua Kyalo. I am an advocate of the High Court of Kenya. I practice generally criminal law, banking and corporate law. Those are my area of specialization. I'm a bit well conversant on that and other matters on commercial law and such. Today as you have heard, we are going to speak about or talk about succession. And to kick us off is what is succession? Succession essentially is a process that happens upon the demise of someone, or rather upon the death of someone. That's what we call the process of transferring his property, his things or his belongings to the next, to his beneficiaries. That process is what we call succession. And as stated, succession happens when someone dies.
Okay.
So any transfer or movement of assets or belongings to someone while you're still alive, we don't call it a succession. We can say it's a succession planning, but essentially we call it gifting.
Okay.
For succession to happen, as stated, one has to die.
Okay.
Someone has to die for succession, for us to say that the succession process has begun. We have what we call estate planning, which is now the pre-stage to succession. And that happens in the following circumstances. When someone dies, there are two ways he can handle his affairs after his death. And that is one, by drafting a will, and two, by failing to draft a will. When you draft a will, a process we call it a testate succession.
Okay.
Testate means it comes from the word testament. Testament is like the last words someone has made on behalf of something. Like this is the Old Testament, the New Testament. It's like the final words for a new dispensation or for the old dispensation. So when you die, we say it's the last will and testament of someone. So and, that we call testate succession. In the event you die, which is the most common way, is without a will, we say it's an intestate succession. Yeah.
So before we go into the deeper understanding of these two, should they be written or they can be verbal communications? Which one can stand in the court of law?
Obviously, will has to be written. A written will carries more water, carries more value than an unwritten or a verbal will. So for a written will, there are provisions, there are conditions on how it's supposed to be written. The beneficiary, the person who is writing it is called the testator, has to write it while he's in his right faculties, in a sober state. He was not drunk. He was not in contemplation of death. And the other thing, it has to be witnessed. It has to show the beneficiaries. It has to clearly describe the assets and the property. And for an oral will, on the other hand, an oral will has to be also to be witnessed by two competent and sober witnesses. And in most cases, there are usually a lot of issues when something is not written, because you don't really understand or really know what happened at that point he wrote that specific document. So in this case, preferably, or rather what is usually advised and what courts will give more preeminence is a written will. A will has to be written.
You mentioned something about somebody who did not contemplate to die. But we've witnessed or we've seen in our news or media people who wrote a particular document and they left it. How is that treated?
That's different. We have something in law called donatis mortia cosa. That's a gift in contemplation of death. And sometimes most people mistake that for a will. It isn't, but it is part of the legal structure of wills. It's somewhere inside there. Because if, for example, if I am traveling via sea, and probably the journey is probably going to take a month or two to reach my destination, I will leave having written a certain will that in the event I die, this is supposed to go to this and this person. That's more of a temporal document. If you are going for surgery, you can just write, in the event I die, this and this needs to be done. But there are a lot of legal questions that usually arise in such circumstances, because someone has to be really in a position that he actually apprehends that he might die. So that's why we call it a gift in contemplation of death.
Okay.
But it's also a valid document. But for wills is quite general. Will is the actual document itself that gives credence to all those assets that you have on how you're going to distribute. You have to be sober, you have to be in your right mind. You don't need to be coerced or pressured by things. Yeah. It's just planning your afterlife affairs. Because I'm sure most of you have seen the issues that arise on the media generally. You see people fighting for property.
Exactly.
Here, left, right, and center. Everyone is just going, this one does this, he goes to court, or this brother does this, he goes to court. And most times is challenging of wills. And for wills to actually remain solid, there are various things that need to be there. As I've stated, it has to be executed, or rather executed by the author himself. He has to show the description of his property clearly. You can't come and say, my land I give to person X and X. Which land? What size? You know, those are the questions.
So the specifics have to be there.
Specific. If it's a 1 acre in a Romoroti, you say my 1 acre in a Romoroti to be distributed as follows, between my 4 children in equal share. So each gets a quarter of an acre. And you describe the land in a Romoroti. Probably you may have 3. You have to say my land in Romoroti, plot number 1045, something like that, to be distributed amongst my 4 children. So you have to be a bit very, very descriptive of that. And also the other issue that needs to be there, you need not to leave out beneficiaries. If you have 4 children, let it be 4 children. If you have 10 children, let it be 10 children. But don't say, because I don't like children X, I'm not going to distribute my assets to child X.
How does the law stand to defend that one? And it is I who wants to distribute what I owed. I mean,
I think essentially is what we say is that a child is a child, whether born in wedlock, out of wedlock, a bastard, hated or loved. A child remains a child. He does not lose, or she does not lose, that status of a child. So the law protects children. Yeah, the principle or the spirit behind it is to ensure there is no destitute children or people in this world. Yeah, you cannot say you are a billionaire and all your things you have distributed to charity and left your children suffering, so that the state or someone else picks your tab. Now the law is against that.
So in an event where somebody did such a thing, can it be contested in a law court?
Yes. Most succession cases are because of that. And the only exception the law provides is that if the child is part or directly linked to the death of the executor, he cannot or she cannot inherit. Just in simple terms, if my father today, I go and I hire hitmen, they kill him. In that will, I am not entitled to benefit from him because his death is as my result. So I should not be given. Though I'm his child, the law ensures that it protects even the person, that no unscrupulous people benefit from the death and the misfortune of someone.
Okay.
Yeah.
Okay. If we go forward and look at how does one write a will?
Okay. So writing a will, first of all, the biggest challenge in writing a will is the issue of us being Africans. Writing a will, most people consider it to be preempting your death, and it is wrong. At the end of the day, none of us will leave this world through a door or by train or by air. We are all going to die. For man, it is appointed to die.
Yeah.
And so it's bound to happen. The best way, first of all, is to kill that bias. Then once you kill that bias, you can now start the process of writing a will. There is no standard format. There is no standard format. The only standard thing that needs to be there is be witness, be of a sound mind. You do not leave others, neglect others in your distribution of your assets, and being of a sober mind. Just that. Those are the basics. You can write. I have seen wills written in an exercise book with around 5 pages.
Wow.
And the court has upheld. So you say, upon my death, this is to go to this person, this person, this person. And then you write what we call an executor or an administrator. An executor, rather. The executor in that case is someone who, upon your death, will come and execute your wishes. So he is the one who will probably hold the will in trust and say, he calls a meeting of the children and the beneficiaries, say this is the will, this is the copy of a will to the children, this is what your father or your mother said, this man is going to A, B, C, D, this one is going to you, this one is going to you. He wrote it, this is his signature, and these were the witnesses who were present on that day. If you have an issue, you can challenge the will, but that's usually the standard format.
I'm just concerned. How two things. When writing a will, do I involve the people who will be beneficiaries? And two, how do you determine that the executor is giving the actual wish of the person who is succeeding these properties?
The best solution usually is you don't need to involve the beneficiaries. And in most cases, we ensure that you don't have any beneficiary when you're writing the will. Reason being, he might influence your mind. The others may challenge and say, when he was writing this will, he was with person X, he was with our elder brother. So they used to be close. And when they look at the distribution, they see that probably he has gotten the prime assets. He's the one who has gotten the plot that faces the road. While the rest of you are around 2 kilometers inside. And he has been given a flat, while the rest of you have been given some small portions of land somewhere else. So he stands to benefit more. So those are the issues. So for purposes of good practice, you don't need to have a beneficiary there. Secondly, on your question as to how do we ensure that the executor will actually do the right thing, wills, you need to do the wills most of the time in 3 copies. And the best place is to take them to an advocate's office, a good advocate of good standing. Place it there. You can take another copy to a safety deposit box, either in any bank, and pay for it. That upon the death, they will see the actual copy. Yes.
Okay.
Because the only person who has access to that will be the beneficiaries, not even the executor. So you give one to the executor or the advocate, one you place it in a safety deposit in a bank, and one you can just give it to a friend. I'm sure you can't lack one friend who you trust.
Exactly.
Yeah, just one. At least he keeps the copy. So to finish those issues that may arise here.
I'm also looking at how at what point do the beneficiaries need to know that you've written a will?
There is no point they need to know. Beneficiaries only remember that there is a will when you die. Because upon your death, they know Mzee has gone. So your other person who you have given the will, the executors, will come and inform them. Yes, we know Mzee has passed on, but there was a will that he had written on how all his affairs will be done. So once probably you are done with grieving, you can come and look at the will. We can even set up a meeting and call all the beneficiaries and come and see. Yeah.
And what are the advantages of writing a will?
Number one advantage, it saves you a lot of costs, legal costs. It saves you a lot of legal costs, unlike when you haven't treated one. Secondly, it is quite effective in terms of management of your affairs. It gives court certainty, the third thing, that there is a document and you are here to enforce it in the event of anything. So if you go apply for the distribution, you have a will, you go to court, they'll give you the necessary documents for you on how you ensure and follow up on the distribution of the assets. The other thing is the will in itself, it being a valid document, courts can stand by the will. That's the advantages of a will. The disadvantages of a will, I don't think there is any, other than the fact that just that African bias, it preempts death. Just probably that is the only one that I can actually think of. That you may say this is a disadvantage of writing a will, but you know that happens to probably if you are a bit superstitious. But nonetheless, at some point you have to die, so you need a document. So that's certainty, and it avoids family wrangles.
Yeah, true.
That's another thing of having a will.
You've mentioned a lot about our African culture, and of course we believe that everything has a cause, being one of the core belief system of us as Africans. And at what age should one write a will? And can it be amended or edited as you go along?
Yes.
Labda I wrote it when I only had one property, then I've lived 50 years later.
100 and more. A will, essentially, the best way is to write a will. You keep updating your will. The minute you get assets, you see substantial assets, and you have children, the best way is to start as early as possible. You go draft a document, your will, and say this is how I will distribute my assets. And with time, you get some more. We have what we call, you can do an amendment. You can amend the will by something we call a codicil, which changes the entire will and says these are my new assets. So the will that was dated, let's say, 20th of December is hereby stand revoked. This will be the new will going forward.
And that's a legal document from...
Yes, because you have added new assets. Even probably with the time, you may even, God forbid, lose a child. And they did not have any beneficiary. So you'll amend that and remove him from the beneficiaries and distribute. If there were 3, now each person gets his portion again, you distribute it again. Yeah.
Before we take a break, assuming this person is married, and should the will be done by the couple, or can the husband or the wife do it independently? How does this union play?
Now, for a will, it's a personal document. It's like an ID. It's not the last and will testament of Njama and Mrs. Njama. A will is separate. the will be done by you because the things are yours. That's what happens. And upon your death, there are some presumptions that we usually have. We always have the presumption that the younger person will survive the older person. So if I am, let's say 30, we assume that the person who is 28 will survive me. And probably, sometimes it doesn't go like that. Some people are even 80 today and they have lost their children in 40s and 50s and this thing. But we usually presume that. Secondly, we always there is a presumption that the wife will survive the husband.
Okay.
Yeah. So there is that presumption that baby will remain, the man will go first. That's one of the presumptions that we have. So for such scenarios, what is left, whatever you have, does not belong to the wife or your spouse. It belongs to your children. Yeah. But, and I've said a strong but here, is what we call who will be holding those assets in trust. And the surviving spouse is the one who holds in trust for the benefit of the children.
Okay.
She has a life interest on that asset that she holds on behalf of your children. What do we mean? It means that as long as she's alive, she holds in trust those assets that you left behind until they reach age of majority.
Wow.
Once they turn 18, she has to transfer the same things to them.
Yeah. Is there a possibility that if he or she is holding the property in trust, they can use them to get a loan facility or such kind of things?
Yes, they can use them to do such things. But the only challenge is most people and even most institutions don't usually understand the legal nitty-gritties of such issues. Because if she holds it in trust, or if he holds it in trust, he should not be able to use it for other unscrupulous businesses. Because someone may just go and take a loan of, let's say, 10 million and enjoy that money. Then upon their death, they come and they realize our dad had left us property worth this amount. However, the property, the person who was to hold it in trust, either our mom or our dad, went and took a loan and enjoyed with all that money. So there will be other issues, and you see the bank will have rights over that property. So there are a lot of legal challenges that happen, especially with that question. And most of the time, I'll advise anyone, if there is such an issue, consult a competent advocate. He will give you and he will plan for you those issues. Because of that element of holding a life interest on the asset for the benefit of the children. There's also the interest upon remarriage. The assets should be taken to the children. They should not even be dealt with in any way. But those are just arguments that people continue to push. But the other issues, I think, we will address when we look at someone who dies without a will, an intestate succession.
Thank you. We'll take a short break, and this is your legal show at Just Connect Online TV. Thank you.
Thank you.
Ever felt the need to learn how to play a musical instrument or improve your music skill and never knew where to go? Just Connect School of Music is the place to be. We offer professional training in music sight reading, piano, drums, guitar, saxophone, bass guitar, and vocal training. We are located at Eprin Square, 3rd floor, room 26, opposite Buruburu Police Station. Just Connect, building worship.
Welcome back. This is Just Connect Online TV. On your legal show, we are addressing the issue of succession. Karibu sana. We were at a point where we were looking at the revocation of a will. You addressed the issue of updating a will. Is it possible to revoke a will?
Yes. you can revoke a will. Number one, you can just, I can give the easiest example, tearing up the paper that you wrote. Actually, there's a provision for that in the law. But still, there needs to be no other copy. So if you tear the only copy, that's it, you have revoked the will. There's amendment through writing a new will, and the other one stands revoked. And there is, those are the main ones, revoking by writing a new will, tearing up, and also there's one that I can't quite remember, but I will let you as with the time as we go on. But those are the methods in which you can revoke a will. And okay, yes, the one where you haven't fully put the beneficiaries in the will, and also the court, through a court order, a court can nullify a will and revoke it and say this will is void. Why? Because of A, B, C, D. Just the way contracts are voided. So a court can issue an order and say this will stands revoked by virtue of it left out beneficiaries. The other thing is if it can be seen that the will was made when the testator was probably insane, or was suffering a sickness that affected his mental faculties. So someone with dementia, and he wrote a will when he was suffering from dementia. If it can be proven and shown that he's actually sick, the will be revoked, because essentially the courts will presume that his capacity was not right at that given time. His judgment wasn't right, hence him writing or drafting that will is a nullity. Those are the main ways in which you can actually revoke a will. The next issue we look at is after the issue of the wills. We look at just in terms of the intestate succession. Intestacy essentially means someone who died without a will. And that is the most common thing that happens. Let me say a thing. Because most people don't contemplate writing wills. Most deaths are not, even if we look at our National Bureau of Statistics data on our population pyramid, most Kenyans their life expectancy is not that high. It's 45, 46 years, which is quite low, unlike developed countries in the 70s going to the 80s here. That makes most people not be really into writing wills. So most people, even with assets, don't write wills. Secondly, the issue of African culture. The bias of writing a will is wishing death upon yourself. It's like you are speaking death. So there is that. The other one is the issue also of culture, in terms of you don't need to write a will. People know how our customary law applies in succession. So there is that. The fourth one is issues like if you abide by the Islamic faith, if you're a Muslim, the Quran specifically and clearly states how succession will be done. So those are the issues that create that environment of intestacy. That results to most of the challenges that we have legally on matters of succession. So when someone dies without writing a will, what needs to be done?
Exactly.
What is the procedure? Because that is the main procedure. The procedure for a will is quite easy. There is propounding, going to court, getting the orders, getting the grant, and confirmation of grant, just that, and then it's a done deal. For a person who dies without a will, we start with something we call getting or taking out letters of administration. So letters of administration purely means the person who will now be able to administer the assets and the property of the deceased. Or rather the estate of the deceased. Estate because it means all his assets and liabilities. So the estate of Mr. X, who died a certain date, will be administered by someone. So the person who usually does that is usually the surviving spouse, or the beneficiaries, or the parents.
Now, when you mean how, assuming there are like 10 beneficiaries or 5 or whatever number, how do you determine who becomes the administrator amongst yourselves, and if there is conflict within?
Now the law allows for a maximum of 4 persons who will be appointed as administrators. And the 4, if all of you believe to be heirs or successors to this person, beneficiaries to this person, you have to sit down, whether you like it or not. The one who's causing conflict, if there's a group that agrees, they nominate one person. If there's one who's saying another thing, he nominates one person. If there's another one who's saying, he nominates one person. So the law allows for 4. So now you have to go get a letter of administration. The letters of administration purely shows who will now be in charge of this estate of the deceased. Once that is done, you go to court. You obviously, there are forms that you fill. They're actually online. And once you fill them, there are affidavits to that. The first thing that most needs to be there is the death certificate that actually this person died. It's not,
the procedure cannot flow without.
You know, it may seem just obvious, but sometimes people take out letters of administration for someone who's much alive.
Yeah,
there are crooks. There are crooks in this country, unfortunately, who do that. And I even know a case here in Buruburu, someone who people took out letters of administration, and unfortunately they got them confirmed. The bank paid money to unscrupulous people, and even had a fake death certificate. But once you get that letters of the death certificate, you have to get a letter from the chief. So here is when you realize these chiefs are a bit important in our society today, because the chief, essentially his role is to confirm this person lived in his locality, and this person died, and this person had children or beneficiaries, A, B, C, D. So a chief writes a letter and he says, Mr. X passed on this date. He was married to this person, and he had the following children that we are aware of. He had 4 or 5 children, and the children are child A, age 10, age 13, age whatever the age, and then he writes it down. So once they take that to court, a notice will be issued for objection for 30 days upon the letters of administration, that if anyone has an issue with the following 4 people to be appointed as the administrators of the estate of Mr. X, they should lodge an objection. So if there is no objection, there is what we call a temporary grant that is usually issued. A temporary grant is given to the administrator to tell them, you guys will be now the administrator of this estate. You can deal with the estate as follows. Sometimes there are conditions, sometimes there are no conditions. It's a bit of a technically issue. It's not as easy as I'm saying here, because there are some things, for probably someone has died, he has millions in his account, the children are reporting to school, the wife has no money. So how do we get those funds from the bank to the school? So we have to get those orders, called grant ad litem. There are so many things like that. They're just numerous. But anyway, for the main procedure, once you get a temporary grant, you have to wait for what we call a confirmation of the grant, which takes 6 months.
Oh my, okay.
Which is good. Why? Because the temporary, someone might still have an issue. The law has to give time to anyone who probably has an issue with the letters of administration, the way the assets are being dealt with. So once the confirmation of grant comes, there's something we call, it comes with the administrator it shows also the assets, how they were to be distributed, because you also submit a list of assets. You will submit that he had the following assets. He had asset A, B, C, D, E, F, G. Those assets. So once those assets are listed, they are divided based on how they agreed, and if they are unable, the court will make the decision to distribute it on their behalf. So you will say this person had 5 children. So how big is this land? We give each a fifth of that land. Yeah. So they just list in equal share, in equal share, in equal share. So everything will be shared equally. Notwithstanding there is notwithstanding the gender, man or woman, you get an equal share.
And in an event, this person had assets, yes, but the liabilities were beyond the assets. So what happens?
So what happens? Even those before the confirmation of the grant, the 6 months, if you have an issue with someone who was passed on, he owed you money, you can go to court. You can petition the court to be added as a beneficiary. There is that trick some laws have seen use, to be added as a beneficiary to pay off, to set off your debt. If probably you had even paid, you had sold your land and you hadn't finished paying, you can go to court and say you have a stake, a right over this asset, because here is a sale agreement that we had. I had paid him, it's 1 million, I had given him 800,000, the balance is 200,000. I asked this court not to distribute this asset. I will pay the remainder, the balance, as we had agreed with the deceased. There are those issues and those circumstances. So the court will allow you to come and add yourself. Some try and become beneficiaries, but there's no full legal provision on that as yourself, because a beneficiary is a child. But there are those grants that sometimes come in such manner, though I don't agree with them legally, but there are some courts that do that. You can add yourself there. You can sue the entire estate and say, this person had A, B, C, D. My debt is this amount. This is our agreement. These are the assets that he staked. So I need my money. I need to be paid. If he's unable, if there are no money in the bank, he has to be auctioned. His assets have to be auctioned. But the only thing is, court's guiding principle is to not leave children destitute. So obviously, the matrimonial property will not be subjected to such a process.
Any other property
the rest can be subjected, but the matrimonial will not. And the court will grant the children, especially if they're minors, a portion of those assets and set off the rest. The person, if he has a balance in debt, he has to accept losses. Yeah. So those are the parts that courts consider most of the time. Yeah.
What is the procedure of the full succession? How does it go about?
So, as I have stated, for the one for a will, it's easy. You just submit the will to court. The court will put a notice on the Kenya Gazette, says there is this estate of this person, grant will be given and the assets distributed.
That is for a person who had a will.
Yes.
So every property is put on the Kenya Gazette?
No.
Or
they don't
possible.
put that. They just put, in case you have an objection with the will, they'll just put the notice that this, in the estate of A, B, C, D, this and this. It's essentially it's to challenge the will. You are given, anyone is always given time to challenge the will. A beneficiary, a debtor, as you had said.
And how long does that process take?
Most times 6 months.
Okay.
Yeah, it's 6 months. But even if someone feels aggrieved that he didn't get the rightful share, so that's the procedure. And then grant is given, you continue.
I'm just wondering, in an event, thank God we have this show to educate our viewers. In an event somebody did not know that was a process, whatever source of ignorance it was, is there a recourse where you can claim any, I mean, succession,
Yes.
yet the period has already passed, the grace period that the
There
courts
is no
give.
grace period there for that. That one you can just petition court at any given time.
Say it, the
Especially-
deceased died 10 years ago,
Even
and
30 years. Even 30 years, you can challenge that issue.
wow.
You can go to court challenge, but you have to show the court why you're challenging so late. And say probably you did not know. So thirdly, secondly, there are other issues that I've seen. Someone says, I recently discovered the person who died was actually my father. So the issue is to come and look if the assets have been utilized or not. If the assets are utilized, then unfortunately you won't get anything. But if there's any asset probably that has remained unutilized or rather undistributed for a period, then you can get a share over that property. Yeah.
And in an event where somebody bought property, no one knows about it, but it belonged to this particular person, how is that treated? I know there is a particular, I don't know whether it's a department within government of unclaimed assets. How will you be aware that a particular property belonged to person X?
The only challenge is if you don't know something, you don't know. Getting to that knowledge of understanding that someone has something is quite tricky and challenging. But the same way we search for things is the same way you have to go to. If it's a land that you don't know, you can go, if you suspect, you can go to a certain registry and ask, there's this person who had a land here. Can you look from your record if there's such a person with any land here in this registry? So you see now that's a process of you moving around, looking at if he had anything anywhere. If it's assets in a bank, you can write a letter to certain banks that you suspect he had money and see if he had anything. If it's M-Pesa, you can write to Safaricom. This person has passed on. This was his ID number. Did he have any money in any mobile wallet? Such a thing. The other thing, you can also write to the Unclaimed Financial Assets Authority. You can write to them a letter informing that this person passed on. Does he have, from your records, does he have anything? Because the law changed. It mandated all institutions and organizations that have assets that have remained unclaimed to every year to be submitting assets that have been unclaimed for 3 years to them.
Okay.
So there's that. But looking for those assets is not an easy task because the person died with that secret. Getting to know if he had it,
it's hard. It's
quite
tedious.
It's tedious. Yeah, and sometimes people even benefit from land and things and assets of people who died, and nobody knows.
Then there is another aspect where a couple, husband and wife, they buy properties, and how are these issues dealt with when one of them passes on?
So whenever there is a purchase or acquisition of an asset by two persons, husband and wife, there are two things that we usually look at. We have what we call joint ownership and a tenancy in common. Tenancy in common is whereby both of you own an asset. Upon the death of one person, the entire asset vests in the surviving person. So the person who is alive benefits from the other, whatever was left behind. If it is a joint ownership, when the person dies, his half or whatever the proportion of his share that he held in that asset is the one that will be entitled to distribution. Yes.
Until now, the other one also dies. Then
Yes, which now goes to the children. Yeah. But even if, but in most cases, there are usually tenancies in common, and the tenancies in common, the surviving person usually gets the entire asset. In terms of, I will talk about beneficiaries. Upon the death of a person, the household belongings and the house, matrimonial home, belongs to the surviving spouse. That one remains unchallenged. the things that are at home remain his. Jewelry remains belong to the surviving spouse. If like this ring goes to my wife, the house goes to her. My clothes, my personal things, my TV, my cooker, my fridge, all belong to her. My phone all belong to her.
What if I brought it? Nikakuachia.
No. That one now will belong to that house. That's.
There is no way you can claim it.
Even no child can claim that.
Okay.
Because we ensure that the surviving spouse continues in a normal life as much as the stability remains. Yeah, that's what usually happens. Vehicles, I've seen conflicting reports from case law. There are some that say one vehicle should remain to be the property of the spouse. There are others that say the vehicle is part of the entire estate. It should be distributed like the other assets. Yeah, but there is no solid conclusion on that. It depends. There are so many issues. And there are so many arguments, legal arguments behind that. But the assets that remain, the wife, as I've stated before, or the husband, holds a life interest over that property. Until when she passes on, that's when those assets, that house will now vest to the children. Yeah, she holds a life interest over that.
Okay.
And even for children who are below the age of majority, below 18, she holds in trust those other assets. So she should take care of them. She is a trustee. So she's bound by the laws that govern trusteeship in this country. So she should act for the best interest of those children with those assets that she's in trust. If she fails, or if he fails, the children can sue her for misuse of those property. Yeah. So there is that. When it comes to beneficiaries, the other beneficiary is our children. All children are entitled to a share of their father or their mother's estate. There are no buts, there are no ifs.
As long as it's proven that they are
proven
biological, or does it matter whether they are biological
it doesn't matter, because there are other questions that I'll address. Biological children, wherever they come from, they are supposed to inherit their father, but not their mothers. And
how so?
In this sense, most married men, or rather some men, have other extramarital affairs, and they get children out of wedlock. So the legal question most people say is, should the mother of that child also get a portion for that other child? But the law recently was amended and said, quote unquote, Mpango wa kando cannot inherit anything, which is true. She cannot get anything. But the child that she bore is entitled to the estate of that father. Essentially, the law is saying, kila mtoto akule kutoka kwa baba yake. Yeah. So that is what happens. The other thing is adopted children, to which the deceased took in, cared for them as his own children, are entitled to the assets of the deceased in equal measure as biological children. Yeah.
So when you mean he or she took, what exactly does that mean? Does it mean that this child was legally adopted, or
legally or otherwise?
Or you are helping?
Even if you're helping, it depends. If the child I say took because he took in his care. That's the legal one. He took in his care the child. For example, right now I go and I get a child in the street. No one wants them. I've never done full success adoption process for the child. I take the child inside my house. I care for her or him as if he were my child. I take her to school. I feed her. I clothe her. I just treat her as equally as my children. That child is entitled to my estate.
Wow. Wow. Wow.
even if it's your brother's children. Yeah.
There is another issue that comes up when people are you are in a how do I put this? You have a life insurance, then there is a person who can benefit, because you're addressing the issue of beneficiaries, or you have shares in a cooperative society, then you've put the person who can benefit from it. How is that treated
So
legally?
that one goes to the estate. That's how it's supposed. That's the general rule. If it's an insurance fund, it should be go to the estate. If it's a cooperative, it benefits to the estate. However, there's that part we write beneficiary. How do you want it to be shared? So you go right there and say, wife 60%, children 20% each. There are two. That's it. So upon their death, the money that is in that fund will be remitted to the wife. The 60% she will get it. The remaining 40% will be held in trust for the children until the age of majority. Yes. The other challenge that comes in that I have seen is people who forget to update their beneficiaries and their heirs. The courts have pronounced themselves on several occasions that those assets should be taken back to the estate. If there are probably more children, they should be taken to the estate and redistributed equally. Yeah, that's what usually happens. Yeah.
As we are almost coming to an end to this, there are issues of polygamy and other issues within family setting. How are these issues treated?
For polygamy, each wife, rather, if they are legally married to the deceased, is entitled to a share to the estate in equal proportion. Not the spouse will just, the wives will get, as I've stated, the homes that they were staying, their matrimonial respective homes. But the assets will all be shared among all those children in equal proportion. Yes.
Whether there was a will or not.
Whether there was a will or not. Children whether born in wedlock, out of wedlock, whether you have 20 wives and 20 children, all those 20 children will inherit you in equal share or based on the will.
We've witnessed these things in the media where a person dies, then a court order is issued. Somebody claims they were a child or a wife to this particular person. What does it mean when the court order is issued? Is it, and will this person be buried after these issues are resolved? Or what is the legal perspective of all this process?
What usually happens for people to prevent burial, there's usually the issue one for preservation and getting of DNAs. Because upon the death, obtaining DNA is a bit hard from corpses. It's tedious, it's a bit tedious. So there's usually that. People usually object that because they want to get DNA, so that in the event of a succession, they can actually prove and show that these things match. So this person who died was the actual father of this person. Secondly, there's also that cultural issue of where someone should be buried. Sometimes within the family, you'll get someone says doesn't want the father to be buried in a cemetery, wanted him buried in a certain land. Or some don't want him to be buried in his land, they want him buried in a cemetery because they want that land to be able to sell it. So those are usually the issues that take people there in court, because and fighting over the body, where to bury it, and also cultural practices, because the Constitution upholds cultural practices. African cultural practices are part of our heritage, so the law has to adopt to them. They don't just brush off or sweep them under the rug because they are just
Culture.
where you get those issues and fighting and conflict over the corpse of a person. But at the end of the day, for me, what I've experienced is just they want the DNA. So there are cases where the DNA samples are collected and taken to the government chemist or to any other private laboratory, and the body, people can now bury the person.
What would be your parting shot, especially on this highly sensitive issue that brings many families down?
I would encourage people to write wills, draft wills. The other thing, I would encourage the men who are watching us, do not have many children within every other corner of the country or the world. It brings a lot of conflict upon your demise. And the other thing is, if you are having such an issue within a family or context, the best way to resolve it is to go to court. There's also another organ that I would like to add, sorry I'd forgotten, it's called the Public Trustee. The Public Trustee usually handles people who die intestate, and they literally have assets that are quite minimal in value, like 100,000. So someone dies, he probably had one plot there in probably, let's say, in Tanariva or Mandera, just a plot, and he died. So that plot is not worth that much. You cannot distribute an eighth of a plot amongst your 10 children. So the Public Trustee will just handle such a case, sell if it's the asset is to be sold, it will be sold, and the money will be distributed amongst the children. So for people, let's say not rich, it's probably quite a bit poor. He had probably 3 or 4 cows, 5 cows. He lived in he was a squatter, such things. So that's why we take it to a Public Trustee. But purely ensure you have a will. Write a will as early as possible. Draft one. It can cost even 3,000 or 2,000 shillings. Wills are the cheapest things to write. In fact, you can get even a template online, write, and have it executed by lawyers and drop it there and just leave it.
Thank you so much for your time and your legal expertise. We don't take it for granted. We really appreciate it. Thank you, our viewers, for taking time to watch this show. And if you have any questions and comments, you can drop them at our subscription down there on the comment section. And I believe that you found this an eye-opening show, and may you have a good time, and may God bless you. Bye-bye. This is Just Connect Online TV.
Just Connect TV is your entertainment and educational channel. We broadcast authentic content that will inspire, empower, and stir up the potential and positive energy in you. Just Connect TV, streaming live.